Someone once wrote that love is grand, but divorce is 100 grand. Any dispute with regard to parents and spouses is expensive. We are very highly regulated on how we charge for legal fees in the state of New York. The court system requires us to have written retainer agreements. We can only charge an hourly rate. We cannot take a percentage of your marital estate as a legal fee. We cannot have a lien on your house or mortgage unless there is court permission. Our firm charges high hourly rates. However, we are efficient, and often the services we perform are less expensive than firms that charge a far lower hourly rate because we do not spend as much time on certain activities as other firms. It is our goal to shepherd you through the process of solving the issues with your spouse or the other parent as economically as possible. In this regard, we discuss the cost of the resolution of matters with you in the initial consultation. It is followed up with a written retainer agreement. We do not charge to discuss our fees. Fortunately, litigation is the most expensive way to resolve any matter. That is because it is the most time-consuming in terms of attorney time. Divorce is especially expensive. There are required forms, court appearances, compliance conferences, and if necessary, a trial that is extremely time-consuming. Therefore, we make every effort to resolve your matter without having to litigate. However, whether you litigate generally depends upon the response of your spouse or the other parent. If in our opinion you will obtain a far better result at the end of litigation, given the attorney's fees that will be expended, then you may find yourself litigating matters versus coming to an agreement. Agreements are preferable. They cost a lot less money because they are far less time-consuming. However, your goal should not be merely to limit the legal fees. If that is your goal, all you have to do is to give the opposing spouse or parent whatever it is they wish, and you won't require legal fees. However, for most people, the goal is to have a fair time sharing of the children, an appropriate custodial schedule, a fair and appropriate amount of support to be paid, and an appropriate distribution of your assets. If those are your goals, then you can measure whether or not you want to spend the money on litigation and the necessary fees involved, or whether or not you wish to resolve things through the offer that is made by the other side. Since October of 2010, there is a new principle with regard to divorce cases that requires the moneyed spouse to pay the legal fees of the non-moneyed spouse. Unfortunately, many judges interpret this to mean that the moneyed spouse does not have to pay all of the legal fees of the non-moneyed spouse, and there is often a dispute as to who is the moneyed spouse. For these reasons, we are happy to apply for support in appropriate circumstances or to make an application to defend support. However, the obligation to pay our fees as well as any other attorney's fees is a matter of contract, regardless of what is ordered by the court.